Mr. Kohberger, do you understand the charge in count one, burglary?
Yes.
Do you understand the maximum penalty?
Yes.
Bryan Kohberger formally asked the judge to dismiss the indictment charging him with the murders of 4 University of Idaho students, as prosecutors asked the judge to bar him from presenting an alibi at trial. Thanks for joining us here at Law and Crime. I'm Angenette Levy. There's a lot of legal wrangling and maneuvering taking place in Bryan Kohberger's capital murder case. He has pleaded not guilty to the November 2022 murders of Maddie Mogen, Kaylee Gonsalves, Xana Kernodle, and Ethan Chapin. His attorneys had previously indicated that they would challenge the indictment. The likelihood of Judge tossing the indictment is very slim, so in the alternative, Kohberger's lawyers are asking that the case be sent back to a lower court for a preliminary hearing. That's a hearing where prosecutors call witnesses to show there's probable cause that the defendant committed the crime and should go to trial. The defense sometimes benefits from a preliminary hearing as they get to question state's witnesses before trial. Since the grand jury basically does the same thing, determines probable cause, prosecutors in the case decided to go that route because grand juries hear evidence in secret, not in open court, and the defense is not there. The prelim in this case had been scheduled at the end of June, but that was canceled since prosecutors used a grand jury instead. But Kohberger's attorneys claim the Idaho Constitution requires a higher standard than probable cause for a grand jury to indict. They argue the standard is actually beyond a reasonable doubt, as it is at trial. Later in the filing, Kohberger's attorneys acknowledged the Idaho Supreme Court later determined probable cause is what's required for an indictment, but they argue the court didn't have the right to change the legal standard. I asked criminal defense attorney James Bogen about Kohberger's argument.
I think that's what you'd call a boilerplate motion, Angenette. In death penalty cases, usually the defense will file well over 50 motions to cover every little angle. And this is one of those things. I think they're also trying to question say that the grand jury selection process and the questionnaire were not proper either. Those are things that tend to be routinely raised in motions in death penalty cases, more to try to cover the record.
What do you think the likelihood of this motion succeeding is? Because they're asking, they're asking the judge, if you don't dismiss the indictment, we want you to send it back instead for a preliminary hearing. They, I think, very much wanted a preliminary hearing because that would have given them an opportunity to cross-examine state's witnesses ahead of trial.
I don't think that this motion is going to go anywhere. In most cases, defense attorneys, we love having a preliminary hearing so we can flush out certain things with witnesses, pin them down about certain points. And of course, you always get a transcript of it. So when these same witnesses testify at trial, sometimes you can go back and go, hey, you really said this.
The issue about whether Kohberger will present an alibi at trial has also come up. Last week, Kohberger's lawyers had responded to a demand from prosecutors that they provide information about Kohberger's alibi, should he decide to present one at trial. His lawyers said they're still investigating and preparing for trial and plan to elicit testimony about Kohberger's alibi through cross-examination of state's witnesses and experts. Philadelphia defense attorney Fred Perry told me recently, presenting an alibi defense is risky.
The presentation of an alibi defense from a criminal defense attorney standpoint is extremely difficult. Once you start the process of trying to have to prove something, the burden kind of shifts because in a criminal trial, a defendant is presumed to be innocent and has no burden of proof. It's the government has to, prove their case. Once you start trying to prove an alibi, you better be able to prove that your client was in a spaceship circling Mars at the time of the incident. Otherwise, the government's going to punch a lot of holes in your case. It's a very, very difficult process.
Prosecutors filed a response to Kohberger and said his attorneys are not complying with the rules about providing information about an alibi. Prosecutors write that Kohberger's defense is required to provide the specific place or places at which the defendant claims to have been at the time of the burglary and homicides in this case, along with the names and addresses of all witnesses upon whom the defendant intends to rely to establish such alibi.
The state is actually correct here. In Idaho, it's different from Ohio. In Idaho, within 10 days after a written demand by the prosecutor for any alibi witnesses and things like that, the defense has to either provide it within those 10 days or at a time that's set by the judge. So it looks to me like the defense might be looking to try to get the judge to set an alternate timeline, saying, hey, we need more time to investigate before we can commit to anything.
Prosecutors want Judge to order the defense to turn over the alibi information or tell them they can't present evidence that Kohberger has an alibi at trial. Finally, the defense is asking the court again to stay or delay the proceedings. They claim the process of selecting grand jurors was flawed because of the number that responded to subpoenas, and they believe that there were also issues with the questionnaire.
I was actually shocked that it was scheduled for trial that soon, because death penalty cases, there's so much stuff to go through. Typically, that looks like a trial date that's too fast for the attorneys to really do their due diligence. They might be. I think that's what they might be doing. I just find it kind of, it strikes me, Angenette, is that they're trying to get a stay on the trial while at the same time they're trying to keep asserting a speedy trial rights. You can't have it both ways, in my opinion.
Bryan Kohberger will be back in court August 18th. At that time, motions about genetic genealogy information and other issues will be argued. For Law and Crime, I'm Angenette Levy.